welcome to the Lawyers, Guns, and Money podcast. This is Scott Lemieux, founding member of LGM and also a professor of political science at the College of St. Rose and a contributing writer to the American Prospect. I have a very special guest today, and it's an exciting moment for Lawyers, Guns, and Money in that it's a podcast not about Game of Thrones. So I'm not sure what our readers will make of this, but I have as a special guest today George Lovell. George is a professor of political science at the University of Washington. He's the author of Legislative Deferrals and a new book that we're going to be discussing imminently, This Is Not Civil Rights, as well as some other major papers on non-delegation doctrine and a couple of widely unread papers written with yours truly. And we're going to be discussing both his new book as well as some issues surrounding the Supreme Court and perhaps a little bit of baseball if we get to it. But we'll focus on the meaty substantive issues first before we get to the really important stuff. So welcome, George.
Thanks. It's an exciting day for me too to be part of the podcast for Lawyers, Guns, and Money.
Yeah, well, I'm very pleased you could join us. So let's start with the recently concluded Supreme Court term, which was an unusually impactful one for the current court. That whereas last term will be defined almost exclusively by the Affordable Care Act decision in hindsight, there are obviously lots of major decisions this week. And as I said in my roundup piece, it's obviously not surprising that most of these decisions are really terrible. But what struck me was just the appallingly shoddy level of craft in most of the majority opinions. And this, by the way, not just the ones I disagree with, but frankly, Kennedy's opinion in Windsor was almost as bad as Roberts' opinion in Shelby County. That that the Supreme Court, as is often accused of, is sort of playing a bigger role in American society while doing a particularly bad job of justifying itself. I don't know if you thought the same thing, having had a chance to look at things, or if you had a different take on it.
Yeah, I mean, it was a disappointing term, to say the least, on a lot of levels. Even the good decisions were bad, and it's almost like they didn't even try. I think, especially in the Voting Rights Act case, there wasn't really much of an effort to reply to Ginsburg's dissent or really to take on any of the core arguments that were being made on the other side in the case. So, yeah, it's pretty devastating, and you wonder if they've just sort of given up on craft and having a coherent narrative behind what it is that they're doing.
Yeah, reading Shelby County, all I could think of is William Rehnquist saying, "Don't worry so much about the reasoning," which is apparently what, in the later parts of his tenure, he used to tell his clerks. Like, it doesn't, and I know this is something that's dear to your heart too, but what I thought of when reading Shelby County was not so much say Plessy or the civil rights cases as Seminole Tribe, which most of our readers won't know about, but turned out to be a very important decision, creating this right to sovereign immunity. And Rehnquist could just barely be bothered to make an argument at all. Like, literally, right. It's like his dumbest clerk, took some Ambien and sort of spent 10 minutes writing something up. And Souter's dissent in that case was just absolutely devastating, and they made no attempt to respond to any of it. And really, at least Seminole Tribe was a relatively minor case at the time, whereas it seems to me that when you're striking down probably the most important civil rights statute ever passed by the United States Congress, I would at least like to see a little bit of effort on things like not just and again, I don't mean to sound like a formalist, but it seems to me that you should at least be able to identify the part of the Constitution that's being violated. It seems like a minimum standard. And as you say, no attempt to respond to Ginsburg on, say, the bailout issue. How can you say that the formula has been static when, in fact, many states have been able to get out of the pre-clearance requirements? And again, there's really no serious effort whatsoever to respond to any of those.
And I think also where it really went wrong is just, the whole premise of the case of questioning whether Congress had adequate justification to single out those states. It's not, it's clear, and I think the record makes it very clear that those states were having problems, and that what Congress was doing and what the Justice Department was doing in the cases where they did do the preclearance was trying to protect the rights of people from being discriminated on the basis of race. And the Constitution very clearly gives Congress the power to do that and the federal government the power to do that. So this question of proportionality and whether they singled out the right states, I mean, that's a question for Congress under the Constitution. It's not a question for the court. So there was a lot of weighing of evidence and picking through the details, but I don't even know that, I mean, that the threshold question of should the court have any role in answering this question at all, given that the Constitution very clearly lays out the power for the Congress, was just sort of skated over. And the opinion hardly said anything about the 15th Amendment. The lead opinion hardly said anything about the 15th Amendment.
Yeah, and I mean, and that's exactly it. That essentially what Roberts seemed to be doing was smuggling in a narrow tailoring requirement, saying basically, if you're going to justify this extraordinary intrusion, you have to do the perfect, that it has to be exactly the pre-clearance, formula that I would like. And granted, I would much prefer to have national pre-clearance or a much broader pre-clearance, but again, that doesn't matter because, as you say, the 15th Amendment unambiguously gives the power to Congress. So it doesn't, all that's needed is that the policy be in some way rational, which it clearly satisfies, and Roberts doesn't say otherwise. That it's not, you could solve, Congress is not obligated to solve all problems when it solves some problems through its valid powers. And Roberts really, and I say that he's smuggling in a narrow tailoring requirement, but he wasn't even, he wasn't even going that far. It's just implicit. It really was not clear what the standard of review is.
Right. And that's the troubling thing going forward. It's not clear what Congress can do now that's going to satisfy the court, because there isn't really a clear standard that gets set in the case of what's going to be good enough. I assume a national preclearance thing they'd say is going too far, but singling out states or jurisdictions is, they're probably going to have the same problems with. And that's assuming, of course, that Congress could actually get anything done on this, which is very unlikely now.
Right. There's two important points. One, I said that in my wrap-up at the time, that it's pretty clear that, that there's no way that Congress is going to be able to satisfy the Roberts Court. That if they single out states, as you say, then they're violating this newly minted principle of equal sovereignty of the states, whatever that means, who knows what that even means. But if they have national preclearance, then clearly that's going to run into a congruence and proportionality standard. The friend that, and the key here would be, for example, United States versus Morrison, in which Congress responded to Lopez and came back with just reams of evidence about how violence against women affected the national economy, and the Supreme Court said, not good enough. So it's pretty clear there's no way. Since it's near and dear to our hearts, I do think it is worth talking about the potential congressional response. That this case, like City of Bernie, and since I'm about to send off a paper on this subject, may seem like the clearest possible example of judicial supremacy. That you basically have Congress wanting to protect minority rights and the court not letting them based on their powers. Having said that, and here I'm almost tempted to, I'm going to offer a half defense of Scalia's crazy rambling about the case of oral argument, which is that there was one thing Scalia was right about, which is that this apparently large bipartisan majority was at least halfway very shallow. That Republicans may have voted to reauthorize the existing legislation, but I think we're about to see that their actual support for civil rights legislation is actually very, very narrow. That Congress should logically respond to this. That the opinion was at least superficially minimalist. Roberts didn't explicitly strike down Section 5. He left Congress room to maneuver, and now both of us think that probably the Supreme Court would find fault with anything, but you never know. If Congress passes something, the personnel might change. You might be able to awaken Anthony Kennedy's sporadic conscience. It's worth at least trying. What I think we're going to find is that, as with Citizens United, the alleged bipartisan support for this is not really there. And so really what appears to be judicial supremacy is much more the Republicans on the Supreme Court doing the dirty work of Republicans in Congress.
Right, and I think the other thing is the Republican Party has changed a little bit since the last time they updated the law, and certainly since when they were updating it earlier on in the prior cycles, where there's, I think there's a issue of sort of norms and culture where the Republicans have gotten a lot more bold about voter suppression and made it a sort of central and open part of what it is that they're doing to counter the political situation that they're facing more generally. And so, they used to be ashamed of it. Rehnquist had to lie about his what was it, the voting place work that he was doing.
Oh, right. There's a polling place goon in Arizona. Yeah.
Right, and now that, because people were embarrassed by doing stuff like that, but now they're not really embarrassed by it anymore. And so that's a really disturbing development. But I just, I think in a way the politics around it are okay in the sense of arguing that people should have the right to vote and protecting the right to vote and devoting resources to that, I think is something that would sell in terms of the popular will and be politically effective. But, our institutions are not working in a particularly majoritarian or responsive way now. And I think the Republicans have a lot to gain from being able to manipulate districting and being able to manipulate access to polls. And so I don't think they're going to give that up easily.
Yeah, that's one obvious problem with the sort of counter-majoritarian difficulty way of thinking about the relationship between courts and legislatures, is that it's crazy to think of American legislatures as being majoritarian. You know, they're not majoritarian in principle and they're not majoritarian in practice. Right. And I think we're going to see that.
Right, and what we're seeing on the court, I mean, John Hart Ely's famous book on the Warren Court was about how what they were doing was representation reinforcing and making sure that democratic processes worked effectively. And the trend you see on this court is sort of the opposite. It's the lack of representation or the disproportionality reinforcing court that, and especially I think the trend is, and people still talk about the Supreme Court as this protector of minority rights, and that's their role. But since the sort of Rehnquist court, the conservative majority emerged on the Rehnquist court, what the court has been doing is preventing majorities from protecting the rights of minorities,
right.
Which turns the whole thing on its head. And the argument by conservatives before was always, well, it's up to the elected officials to go and protect rights, and that's where the case should be. And so now when they do that, the court is preventing them from doing that. It's on women's rights, it's on the rights of disabled, it's on religious liberty, voting rights, and other things where the court is interfering with the capacity of majorities to try to protect minorities through the political process.
Yeah, and of course Fisher would be the other example here, although they didn't quite get rid of affirmative action. And I can't wait until Jeffrey Toobin gets the scoop on what happened with that. That it took them 8 months to come up with, I was expecting about a 200-page Breyer dissent, and it turned out to be as perfunctory, So there was clearly some kind of coalition fell apart in the middle of those deliberations.
Yeah.
But that's, I think, and I've never agreed with Ely about everything, but I think Ely had a very powerful argument about affirmative action, which is that you don't need judicial review to stop, majorities from penalizing themselves. That's the fun that there are many problems with treating affirmative action in the same way that you treat racial classifications in a caste system, but that's one of the most obvious. Segregate. And this is was particularly problematic about Thomas's concurrence, where he essentially that the supporters of affirmative action are the real racists and are making the same argument that the schools did in Brown versus Board, and the same argument the court made in Plessy. Well, the problem with that is that African Americans generally support affirmative action. They didn't support segregation, and they had no political role in even attempting to get rid of segregation, which makes the comparison problematic.
Yeah, I mean, Fisher, I think it's hard to figure out what happened in Fisher. It's also hard to figure out what happened in Hollingsworth v. Perry, because I think they should have done a dig on that case, as it turned out, and then they set this standing precedent that it's not clear what it means, but it doesn't seem good, and it doesn't really seem consistent with positions that the justices had taken earlier on standing issues. So it's an odd case.
Yeah, there's a couple, and that's I'm thinking of writing this up, and I've really gone with it. So a couple people have said that, well, what it probably means is simply that Kennedy had made clear that he was not going to strike down Prop 8, so that's why the 3 liberals joined the majority. The problem is that can't explain the votes of Alito and Thomas, who voted inconsistently on standing, and also can't really, maybe Sotomayor only joined after, but I don't really see that. I have a kind of a theory. I pitched this to Slate but was turned down. But I almost wonder that part of what may be going on here, and this also may explain why, speaking of a lack of standard of review, I still don't understand what standard of review Kennedy applied in the case. He sort of, there's a little federalism and there's a little equal protection and a little due process, but, as I said in my piece, he sort of, awkwardly flirted with all these things, but then didn't invite one to the dance. Sort of all with some weird combination of the 3. But I wonder part of what's going on here is that it not only does Kennedy sort of have an instinctive support for gay and lesbian rights, but was unwilling to create a national right. This also seems to be exactly what Ginsburg said the court should have done in Roe. Basically, strike down the law at hand, say nothing more. As you know, I don't actually believe that Ginsburg is right, that would have created less of a backlash. But in a weird way, I wonder if what can explain this vote coalition above all is that that's basically what, in a sense, Ginsburg and then persuaded Kagan and Breyer actually wanted. That it was sort of the moderate liberals who just said, let's just strike down Prop 8, let's strike down DOMA, and then leave to fight another day. And we're creating a bad standing precedent, but, standing. I mean, nobody ever adheres to standing precedents anyway, so big deal. So,
right. Yeah, I mean, maybe that's what it is. I think, and it's interesting. I mean, that might have been part of what they're thinking. It might have just been a sort of pragmatic thing that was the best they could get, and it was better than having Kennedy write the majority opinion. And they get that outcome by going along with that, because California then, California joins the states that allow the marriages. So it ends up being an okay outcome for them. I think, the other thing that I thought was interesting in the last week was just the timing of the cases and the order that they did them in, because I think, the big case, ultimately, the one that makes the biggest difference long-term is the Voting Rights Act one. And that's also, I think, the most outrageous one in terms of there's no originalism or there's no real consistent argument at all. And so that was making big news for that one day, but then the gay marriage cases came down and it completely pushed it off out of the news cycle, and no one really is paying as much attention to it. And it sort of reinforces this idea that the court is this protector of rights and protector of minorities somehow. And so if they'd been decided in the opposite order, it might have played out a little bit differently, at least in terms of the immediate reaction to them. I don't know if they're that crafty or not in terms of timing things, but that might also be part of what was going on in Fisher versus Texas, that they decided they didn't want to do the Voting Rights Act and affirmative action at the same time. And the Voting Rights Act is sort of the first step, because it maintains political power for the people who they support and helps to do that. And so by getting that case out, then they can do affirmative action in the next term.
Right, I would agree, yeah. And again, whether it's conscious or not, I don't know, but I always sort of assume the same-sex marriage cases would come on the last day, partly for that reason. It's sort of after, a relentlessly anti-civil rights term, it's a way of saying, oh, but by the way, we're still the civics book protector of the rights of minorities, not going too far in that way, but at least advancing the ball a little bit. And we really should talk about not just the Voting Rights Act case, but the extremely important case is gutting the importance of the Civil Rights Act. And that really is a situation where, unlike most of what we're talking about here, Congress did its job. Not only passing civil rights legislation, but updating civil rights legislation in 1991 clearly directed at exactly that kind of interpretation. That exactly what Alito did was what Congress was trying to prevent. But it really is difficult in our system, and not so much because of, these are statutory interpretation cases. They're not cases in which the court has the final say on paper. It's just that our system has become so dysfunctional and Republicans have become so hostile to civil rights that you simply can't correct these problems if Republicans control any veto point. And so the contrast between 1991 and 2013 here is really clear. That with the Republican Party of even 20 years ago, you might have been able to restore some of these rights to litigate successfully, whereas now there's really essentially that the Republicans on the court will have enough support from the Republicans in Congress that basically they get the final word, which I think is disturbing, but it's not judicial supremacy in the classic sense. It's much more about sort of a general dysfunction in the American political system, which is obviously
I mean, I think the general thing in this, there's the growing literature that was the big wave in political science about thinking about judicial power other than in the counter-majoritarian framework, and looking at how judges are integrated into the political system and their power grows out of that. I mean, one opportunity that judges have to, and that the Supreme Court has to exercise a lot of power, is in cases where the other branches are divided or dysfunctional. And so if they can't be overridden, then they can sort of act on their own. And when you put together something like Citizens United and the Voting Rights Act case, then they're changing the underlying terrain of the politics as well in a way that's favorable to the side that they favor. So it's quite destructive, and it allows the court to have a tremendous amount of power and influence on the political system. I don't know that it's necessarily judicial supremacy in the sense that they can do whatever they want if the other branches are united against them, but it's just a reflection of a more general dysfunction in the political system where just nothing can get done, and all these pressing problems that we have that could be solved are not getting solved because of the breakdown in what's happening with legislative institutions more generally.
Yeah, and a final example would be a case the court's going to deal with next term, which is that unbelievable D.C. Circuit opinion, which not only basically rendered appointments to the National Labor Relations Board
Right.
retrospectively invalid, but wrote it in a way to essentially write the recess appointment power out of the Constitution. So
Right.
it could have at least ruled narrowly and said the Congress wasn't in recess, but it basically said, only recess appointments in cases of emergency for somebody the president appointed during the it was just,
Right.
and essentially what the upshot of that opinion is that the president has to fight by, 18th century rules while Congress is allowed a 21st century application of the advise and consent power.
Right.
So as you say, you have a situation of divided government, and the courts can force one side so that rather than using the recess appointment power as a way to respond to the fact that the Senate just will try to nullify whole parts of the executive branch by refusing appointments, the sort of conservatives on the D.C. Circuit can just say, sorry, only
Right.
the Senate can obstruct presidential powers, but not vice versa. And I think
Right.
it'll be interesting to see what the court does about that, whether they at least rein it in a little more minimalist, or whether they, as they have in some labor rights cases, just go all the way and take the full Janice Rogers Brown approach. I also enjoyed the one about how you can be forced to post notices that you have the right not to join a union, but you can't put up legal boilerplate informing you of your right to join a union, which was another classic example of that.
Right. I mean, and there's another, there's the card check case that's coming down as well that I think Eric had a link to on the article about on the blog, on your blog yesterday. So there are frightening things that can potentially come down on that. And I think the other thing to see about this obstruction stuff and also getting rid of the recess appointment and what that does to the appointment power. And, in the political culture, everything is supposed to be, well, both sides do it, and everything, if you criticize one side, you have to balance it out by the other side doing something irrationally. But I think there's a substantive policy thing about obstructionism as well, which is that, it's not neutral to just obstruct regulatory agencies in terms of the preferences of Republicans versus Democrats. It very much favors the Republicans. They want to shut down the government. They want to stop these regulatory actions. So their obstruction is a lot more effective than if the shoe were on the other foot and it were the Democrats doing it. So gridlock is not policy neutral. This is a point that Hacker and Pearson make in their book and talk about it, but that policies just sort of drift away and don't do what they're supposed to do when they can't be updated. And so, yeah, I mean, I think that if they side with the D.C. Circuit on that recess appointment case, it really alters the appointments power. It means that the president either has to capitulate or that the regulatory agencies essentially get shut down. And neither of those are good outcomes.
Right, and as you say, it's not symmetrical. The Democrats can't respond in kind by serially rejecting Supreme Court appointments or refusing to stack executive agencies, because Republicans don't care if the federal agencies are effective.
Right.
It doesn't, you can't, just the cycle helps Republicans. That's
exactly right. And what we're seeing, I mean, with the breakdown of the NLRB and the lack of enforcement is, just rampant violations of labor laws that go completely unremediated as a result of that. So that whole system of sort of collective bargaining and representation is starting to fall apart. And I think that's part of this same story about the political consequences, because labor has lost its voice in politics, and that's changed the sort of class politics of the Democratic Party in ways that have resulted in certain kinds of policy outcomes that we're seeing on a lot of issues. So it's all, the old consensus and the old model that was was structuring American politics for a couple generations is really falling apart, and it's not clear what's going to replace it yet.
Right, and it's really not clear if journalists will ever be willing to get rid of these both sides do it equally conventions. I was amused to read the sort of ongoing Slate roundtable on the Supreme Court, because two of the people were both Richard Posner and his son Eric were both kind of moderate conservatives, both sort of throwing up their hands and saying, no, you're right, these people are wingnuts. I concede the point. I mean Posner almost looks like a like he's like a moderate liberal now. That really shifted, and certainly there are some of these dissidents like Posner and like Josh Barrow and so on, some of the kind of old line Republicans or Norm Ornstein, that kind of the people. But it really doesn't seem like, it seems like journalists are still, it's still hilarious to go back and read what the Washington Post and Time were writing about the Alito nomination. This nice, moderate, reasonable guy who likes baseball and nice to his grandmother, and he's not a big meanie like Scalia, when it was obvious at the time that if you had to choose choose between the two, you'd vastly prefer Scalia, who,
Right.
with Scalia and Thomas, at least their conservatism is, leavened by some interest in legal theory, which on second-order issues they're willing to occasionally follow. Whereas with Alito is just having the most recent platform of the Republican Party in human form on the Supreme Court. But it's easy to make appointments like that, even if they have a paper trail, because there's just, you're just not supposed to say that there may be asymmetry between
Right.
polarization.
Right, and you mentioned Norm Ornstein, and I think that's a sort of telling example, because ever since he wrote that last book that was critical of Republicans, he's now sort of no longer a talking head and no longer welcome, because he's a partisan rather than a neutral person anymore. So he's suddenly a hard-wing lefty because he criticized the Republican Party.
Right, that's exactly it. Keeping on the themes of dysfunctional institutions and hegemony, let's turn now to a discussion of your new book. This is not civil rights, and we'll have to interject I don't know if you have a copy there you can hold up, but we'll interject some fancy graphics here. But
Right.
Just to give readers a little background, your first book, Legislative Deferrals, was a really terrific book, and if I can run the risk of summarizing the argument, sort of responding to the sort of classic comparative politics claim that the explanation for why the United States has such an underdeveloped labor movement is that, is essentially the power of judicial review. It can't be political culture, because the United States in the late 19th century actually had a more radical and advanced labor movement than Europe did. So it's not like there's something about American politics that this just makes it impossible for a labor movement to take hold. So people like, and Vicky Haddam in her own excellent work suggested that the real key thing is the power of judicial review, that essentially Congress would try to protect the interests of labor, which is crucial, because if legislature won't restrict the rights of courts to issue injunctions and won't protect the rights of collective bargaining, there's no way labor is going to prevail in a raw power struggle against capital.
Right.
But you pointed out, sort of looking at labor law in the late 19th and century, and then during the Wilson administration, that's a little more complicated than that. That it's not Congress strongly wanting to protect labor and the courts not letting them. It was much more Congress being essentially ambivalent about labor rights and delegating lots of power to the courts, knowing very well that those courts were reactionary and unwilling to side with labor.
Right.
And you also have a convincing explanation for why labor would go along. It was not because they were dupes or because they thought this was good legislation, but it's essentially, the best case scenario was that the personnel of the court could change. Wilson didn't have to appoint McReynolds. You never know. You might get a favorable construction. But if you don't, then you can use the fact that, allegedly pro-labor legislation was passed to sort of go back and say, well, here's what Congress wanted to do, let's go back and do it. So it made sense for labor, in a sense, to exaggerate the quality of their victory for all kinds of political reasons. So I think that you both have a good explanation for what was going on there and an explanation for the politics of it. So is that a fair summary?
Yeah, I think in terms of labor going along with it, in terms of that part, I think it's that, there's always a point in a negotiation where you're not going to win everything you want, and so you decide to compromise. And in some ways, these were particularly bad compromises, but they were sort of ways of moving things, at least potentially of moving things forward. And that's where you have to go. And I think what other people, so when the laws were passed, the labor leaders did issue these statements saying these are wonderful laws and they do everything that we wanted them to, which, they have certain incentives to do, partly for their membership, but also because that's going to push how any decisions that interfere with that end up getting interpreted. If they make a compromise and they say, yeah, we got this really watered down bill and we're afraid of what the courts are going to do to it, which would have been the sort of honest report, that's not necessarily going to work politically in terms of what the next round of negotiations is going to do.
Right. It's hard to criticize the courts for their interpretations when you say that that's what Congress wanted. That you have to sell the bill by saying Congress wants to protect labor rights. Let's hope the courts will go along with what Congress wants,
Right.
even if it's a lot more ambivalent than that. That there was some support for labor rights in Congress, but I guess this is what we call a legislative default. There's some people who support labor rights, but there are other people who oppose labor rights, and there are a crucial group of legislators who don't particularly care so long as they don't take responsibility for resolving
Right.
the issue. issue, and,
Yeah,
and that's how the courts get empowered.
right. And so, and I mean, the key part of it is making the statutes ambiguous enough that they can sort of support different interpretations, and that's what would happen to the legislative proposals over time. So it's a sort of blame shifting thing, which doesn't necessarily work in the long run, but it can work in the short run in terms of to deflect some political heat off of elected officials. I think the other thing that was going on at that particular time, which is in the first third of the 20th century, is just that it was a fairly new issue, and they were, the legislators were also just sort of grappling about what to do with it and how best to handle it, as workers were, and as there were different ways of organizing during that period, and so they weren't really sure what to do. And so by working it out, not making the legislation completely clear, but having it work out through the courts as a process was a way of doing things sort of incrementally and seeing what worked. But
Right.
they knew the courts were very hostile, so they didn't think it was going to be a great deal for labor, that it was going to end up in the courts.
Right, exactly. So if you want to explain a little bit about the origins of your second book, it started out on at least some of that vein as a kind of about institutional politics, that you're sort of looking at a sort of narrower slice of the New Deal politics that Ira Katznelson talks about in his new book, essentially looking at this nascent civil rights office in the Roosevelt administration. Obviously at this time the Democratic Party needs Southern segregationists to pass any kind of legislation, and quite frankly, although I think we disagree with Kevin McMahon on this, Roosevelt was probably indifferent to civil rights even above and beyond the needs of his coalition. Congress didn't force him to do the Japanese internment, for example. So, but nonetheless, it was during this period in which, the sort of core justices of Brown start to be appointed, and there's at least some effort within the Roosevelt administration to start, looking into these problems. Some of them genuine liberals, including the future Supreme Court Justice Frank Murphy.
Right.
But then you found something, and the focus of the book changed slightly. So if you can explain to the readers what you ended up finding and what you ended up doing.
Right. So it actually, I started thinking about the civil rights section, the original one that was formed in 1939 as the Civil Liberties Unit, before I did the project that became Legislative Deferrals. And I was interested in it because they couldn't get new laws passed. So what the Justice Department attorneys did were experimental prosecutions under old laws that had been lying dormant. So there were some leftover provisions of Reconstruction-era civil rights laws that they did experimental prosecutions with. And I was thinking about it as a way of sort of toying with the idea of, do you try to get legislation or do you try to go to the courts when you're trying to create social change? And so the legislation was bottled up, but then the legislature was bottled up, but then when you sort of look, there's often resources that are there in the law that get forgotten, and it's a matter of making them viable and reviving them. So that's what they were trying to do, and it was a tiny little program in this small office in the Justice Department. It was the first civil rights office since Reconstruction at the federal level. And they were responsible for all civil rights violations in the whole U.S., which is sort of ridiculous during that time period. But they weren't really trying to do a comprehensive program. They just wanted to do some test cases before the Supreme Court. So it was a sort of interest group litigation campaign that was run within the government by one part of the administration, often getting pressure from other parts of the administration not to push things too far, and also getting a lot of resistance from the FBI and the U.S. attorneys when they were trying to do investigations. So that's the sort of institutional story. But then I left that project aside when I was in grad school and did the first book and wanted to go back to it. But what I got interested in instead is I found out in the course of doing some preliminary research that the civil rights section, partly because they were doing some communication with the public and trying to get information about the nature of rights violations, they were collecting a lot of information, including information from individual citizens who were making complaints, and they in various ways encouraged people to write in. And so it turned out they got they got thousands of letters over their first 10 years, often over 1,000 a year, of people writing in and complaining about civil rights. So I thought it would be interesting to know what was in those letters, because this was an era before there were any, we now are sort of used to there being this large federal bureaucracy that protects rights, but this was before any of that was really in place, and there weren't very many state civil rights laws either, so there wasn't a lot of actual protection for rights, and yet people were really writing in and saying that their rights were violated. So I was interested in thinking about what did people think about their rights and how did they talk about rights before we got into this era where there's this stronger actual rights tradition that people perceive growing out of the Warren Court and the Great Society legislation that was passed. So I ended up finding in the archives, I focused on the first couple years that the section was operating. Most of the letters I have are from 1939, and I have about 1,000 letters that I used in the book of people writing in and complaining in various ways to the civil rights section that their rights were being violated. Now, part of what's interesting about it is that almost really basically everybody, with one or two exceptions, didn't get any help at all from the Justice Department. So there was very little response that was made, and yet there was this very large and often growing volume of letters that people wrote in, but they were always sort of put off by the Justice Department, who sort of, in some cases got annoyed that people were bothering them with the kinds of things that they were claiming as rights.
Yeah, and you can explain to the readers where the title of your book comes from.
Yeah, so it's the book, the title, This Is Not Civil Rights. It's one of the very first letters that they got, which is a very interesting letter. It was sent by four women who had been working at the Peoria, Illinois post office and got laid off during the Depression, and then didn't get reinstated with other workers, and male workers with less seniority than them got reinstated first, and they were writing to complain that they should have gotten their retirement annuity. And so I didn't find very many of these, but on that letter there was the routing slip that sort of mapped it through the Justice Department, and it ends up on the desk of Henry Schweinhaut, who was the attorney in charge of the Civil Liberties Unit at that time, and he writes on it in big letters, "This is not," underlined, "civil rights," and says send it to the Civil Service Commission. And that was sort of the reaction that the Justice Department had a lot. They were, they weren't insincere. I don't think it was just symbolic politics. I think the people who worked there were really committed. There just wasn't very much that they could do. But they wanted police brutality and lynching cases, and not in, they got letters about those kinds of cases that they ignored as well, but they didn't want other kinds of things, even though they're things that today we would associate with entitlements that would go by the name of rights.
Right. So the debate that your book is directed in within the law and society literature is this debate about the sort of efficacy of rights discourse. And there's been a sort of major debate between there's sort of to really oversimplify here, there's the sort of one branch of the sort of critical legal studies movement. And I hesitate to mention Mark Tushnet's essay on rights because I'm pretty sure that even Tushnet doesn't actually agree anymore with what he wrote in that article. But say Duncan Kennedy, that there was essentially the sort of the first wave of CLS, which basically said, rights are essentially, a facade, they're a way of duping people, that they're disempowering, that essentially, rights can do very little to advance social justice, but they can just make it seem as if social justice has been attained. And then there were the sort of critiques within, still from a critical perspective, but most obviously Kimberly Crenshaw, the star of the last LSA, and Patricia Williams, who argued, well, wait a second, obviously rights discourse has many limitations, but compared to what? Rights discourse clearly was very valuable in many respects to the civil rights movement and to other rights movements, and if you abjure this sort of American language of rights, then you essentially, you're basically disarming yourself without anything obvious to replace it with. That there's nothing that ultimately there's some truth to the classic CLS critique, but it's not very useful for social activists. And of course, a lot of this was, as he did in many things, presaged by our friend and great mentor Stuart Scheingold in his book The Myth of Rights, who exactly identified this, both the myth of rights but the potential power of rights. So you might think, based on your explanation here, that this is a very critical perspective, and I think your next book will be a very critical perspective, but you actually end up with a relatively optimistic take on rights discourse and the value of rights.
Yeah, and that was something that I sort of learned along the way. I wasn't really sure where I would end up on the book, but I didn't expect it to be optimistic to the extent that it turned out. But I was sort of interested in just considering the empirical question of how do people actually think about rights and use rights. And I thought the neat thing about the letters is it's not in court, where most studies that have at least looked at what people are doing have sort of focused there, but it's actually a political encounter. It's the sort of primal form of political participation is petitioning the government for redress of grievances. It's the only one of those rights that's actually protected in the Constitution, unlike the right to vote. And so these are political encounters where people are sort of engaging in a discourse of rights, and so I wanted to know how they were using it and how it was working. And I think the issue with a lot of the stuff that's been critical of rights discourses and talking about them duping people or being disempowering or legitimating or hegemonic is that they focus on the production of rights ideology mostly by judges. And judges certainly engage in this very ideological discourse when they're justifying the opinions that the decisions that they make in their opinions. And so there's a lot of that, and it's easy to find judges, and it's easy to sort of deconstruct what they're doing and show the contradictions in it. But then the question is, well, what effect does that have sort of trickling down to other people and how they use rights? And I think what the book shows is not very much. The people had this very sort of independent dialectic of rights that wasn't coming from the court at all, because the court wasn't protecting rights at that time or doing very much to do that. Some of it was being borrowed from politics. Some of it was being, they were doing the Robert Cover thing of inventing narratives about American history and about law and sort of embedding these values in it and doing it in a very constructive way. They were imagining rights that they saw in the Constitution that they could often trace to constitutional text, and they were making claims about values and things that were connected to that in ways that were not being dictated by the official version of law, which at that time was exceptionally narrow and sort of crabbed in its reading of how rights worked.
Right, and another interesting part of your book is that it's sort of, a lot of, law and society literature, especially rights-conscious literature, for obvious reasons, tend just to focus on the most subtle forms of power. Lucas's, third level of power, the kind of Gaventa, that the extent to which official discourses just prevent people from forming grievances in the first place. Right. Whereas your book almost wants to restore us to just good old-fashioned, Dawlian, power is a telling beat. It's not, people are perfectly aware that they're being screwed over. Rights are not causing them to ignore injustices or to invent justifications for their powerlessness. That rights don't prevent them from seeing what's being done to them. That it's really right. that really Jim Crow was a very old-fashioned sort of form of hegemony. That it wasn't. Yeah. There were obviously many subtle forms, but there were also just brute, power, and really your letter reveals much more brute power than sort of subtle disempowerment.
Yeah, there's a lot of, just a little bit, half of the letters are complaints about government officials doing things, and there's lots of police brutality, police beating people up, people sort of subjected to false arrests when they were driving with out-of-state plates and things. So there's a lot of just sort of abuse of power like that. And so that's one side of it, is that there was a lot of violence or the threat of violence, and some of it was official violence, some of it was private violence that was going unremediated by state governments at that time. But then the flip side of it is also just saying the people who wrote in, many of them were just very isolated in their predicaments and didn't have any kind of support network or anything, and so they didn't really have much else to turn to. So they didn't get help by writing to the government. It's not always clear that they expected to, but they didn't really have anywhere else to turn to. It's not like they had some other option of going out and voting or engaging in regular political work and getting their problem solved, because that just wasn't a practical possibility for people. So people sort of imagine there's this responsive system, but people are duped into voting for the wrong side or something, and that's the big problem. But I think the part of the problem is the system isn't that responsive, and it doesn't aggregate individual interests very well, at least certain kinds of individual interests very well.
Right, and that's always been the problem with, with Gerald Rosenberg's sort of classic and in many respects very correct book, The Hollow Hope, talking about the limitations of litigation in generating social change. And the bottom line thesis of the book is obviously 100% correct. That litigation right. without substantial support from the political branch is not going to produce much, and often the court's not going to be responsive. All of that is correct. But the problem with the kind of last flypaper court bit is that it ignores the extent to which, again, the compared to what question, that for the most part, all of our institutions tend to be closed off to fundamental social change. By the same logic, why bother lobbying the Senate? Because, if there's a filibuster, if the House won't go along, nothing can happen. That, in a sense, I don't, although I think that some members of the LDF, particularly Marshall, did come to believe that litigation was better than activism in the 60s, the challenge to segregation in the courts wasn't because people thought it was the best strategy. People would have preferred robust civil rights legislation. It's just that civil rights legislation was not an issue. You can't lobby the Alabama legislature from which you're disenfranchised and encourage them to repeal their segregation laws.
Right.
And so that, in a sense, the odds are so stacked against people on the downside of power in the United States that you can't afford to throw away any tools.
Right.
And I see your book in a kind of more, and it's not directly kind of an impact of the court's argument, but I think it's sort of consistent with that kind of half critique of Rosenberg, a critique that sort of accepts his bottom line argument but sort of disagrees about the implications. Would you
yeah,
agree with that?
I think the other thing that it tries to do a little bit is just to decenter the Constitution away from the Supreme Court, and think about how the Constitution can play a different, and does really play a different sort of role in American society in terms of how people imagine imagine how the political world works, and also think about values. And so I thought, one of the things that was interesting, and there's lots of things that the rights language was doing in the letters. It was, it's sort of an assertion of dignity and value as a citizen. It wasn't highly individualistic. People often talked about collective remedies and collective rights, actually more than they talked about it as this purely individual thing. So the discourse is very malleable, but it's very powerful as well in terms of it resonates with people. It resonates with the stories that people tell themselves about what it means to what it means to be American and what American constitutionalism means. And that was true even though it wasn't being reflected in national institutions like the executive or the Supreme Court at that time. And so, the claims that they were making were being dismissed on legal grounds, because based on Supreme Court doctrine of that time, the federal government didn't have jurisdiction over rights, even though the Constitution says that the federal government does have the power to guarantee equal protection of the laws and ensure due process. The Justice Department and then the Supreme Court in some of these cases were reading that very, very narrowly. But the people who were writing were insisting that that was wrong, and they were often writing back when the Justice Department attorney said we don't have jurisdiction because it belongs to the state governments, and people would write back and quote the 14th Amendment and say, what are you talking about? This is what the Constitution says, so that's what you really should be doing, and you're just making excuses. And so in a lot of ways what the people were saying, even though in some cases they're confusing the Gettysburg Address for the Constitution or the Declaration of Independence, and they're not getting all the technical details right, in a lot of ways the values that they were expressing, especially with regard to this question of federal power over rights, were a lot more attractive and a lot more accurate as constitutional values, and closer to where we've ended up, although now that's being pulled back, going back to the first part of the conversation, closer to where we've ended up than we were at the time. And so there's a lot of privileging of the Supreme Court, and this idea that the court gets to have the final say on the Constitution. That's a relatively new idea in American political culture, and I think ultimately quite destructive. I think that the Constitution, and this is where I agree with the modern touchnet, I think it has to be taken away from the courts, and it can't just be trusted to the experts, especially because they aren't acting in good faith, as we talked about earlier in the conversation. And so I'll take my chances. I think it's an odd position to take in the era of the Tea Party and that sort of version of the Constitution, but I think there's a much, you can tell a much better narrative about it, and it's not completely true. I mean, there's lots of things about American history that are problematic all the way through, but there is a positive narrative that can be told about it, and that's a very powerful thing, and a powerful thing politically, and that should be embraced, not just ceded to the Tea Party or ceded to the people on the court who call themselves originalists.
Yeah, your response actually anticipated my last two questions. The first was that, and I should probably run this by you since I actually made this argument in the paper that I presented at LSA, but it seems to me that an implication from your book, in terms of my argument that we should maybe stop thinking about judicial supremacy as describing empirically American constitutionalism, the first thing you note is that, again, certainly ordinary citizens were in no way saw their conceptions of rights as foreclosed on the Supreme Court, that they were advancing interpretations that conflicted with the sort of Reconstruction era school of the court that was still in force, and as you point out, ended up actually being vindicated. That now those interpretations look better than what the Supreme Court was saying at the time. And what's also interesting is that the people within the Roosevelt administration who were at the same time in responding to these letters would say, look, according to Supreme Court doctrine or according to statute, these are not civil rights violations. At the same time, we're working to undermine these precedents from within. It wasn't as if the state officials, either were saying, oh, well, the Supreme Court has spoken, we have to ignore it. You know, basically, many of the people in the Civil Rights Division presumably thought these cases were incorrect, presumably thought the laws were inadequate, but just, you know, so that, you know, their official pose of judicial supremacy did not reflect any, you know, belief on their part. It was, judicial supremacy was strategic. It didn't reflect any views. And I think that, so in that sense, I think your book is yet another example of, you know, I think people who talk about the political empowerment of the courts need to go further and just say, well, do the courts really have the final word on constitutional conversations? I don't, you know, there's really, you know, it's surprisingly hard to show that they do. You know, and I think that that's a classic example. The second thing I wanted to bring up briefly is that, and I think a really important point that you make is that one potential critique of rights is that they tend to be sort of individualistic, that they're disempowering because they sort of atomize and isolate people from communities and from broader political movements, and that can certainly happen. But, you know, your book shows that that's often not the case, that rights discourse is not, you know, this kind of individualized or seen outside of a community focus. And I also thought of another recent book, Emily Zakin's book, which I believe is called Looking for Rights in All the Wrong Places, which points out that if you look at state constitutions, you see an extensive tradition of you know, in Berlin's sense of positive rights. That this idea that the American rights tradition is all hostile to state power, all individual against government. Well, if you look at state constitutionalism, that's not actually the case. That there's a very extensive tradition of positive rights in American constitutionalism, which you can even see in the federal constitution, obviously, with the Sixth Amendment, but certainly if you look at state constitutions, you know, this idea that rights, even in the American context, are necessarily negative or only about restricting state power, there's not a lot of evidence for that. So I don't know if you see any connection between your argument and Zakin's, but at least it made me think of it at any rate.
Right. I mean, I don't think I have very much at all about the state issue, because the people were often turned away by their state governments as well, because people just didn't want to have to deal with the issues. And then in the police brutality cases, the states were sort of on the side of or at least supportive of the people who were doing it. But I think the bigger point is definitely there. There's a lot of things about the way that our system, I mean, if you look at like our statutory protections of civil rights, the way that they've evolved, that they are very individualistic, and they force people to make these sort of individualistic, you know, in race discrimination cases about an individual supervisor engaging in some particular intentional act or something. But that's not how it has to be, and that's not actually how it started off. This is part of what I'm working on with the new book I'm doing with Michael McCann now, is looking at the way that the anti-discrimination law was being used before Ward's Cove and before the 1991 Act, and during that sort of period in the 80s under Reagan and then under Bush, there was this conscious effort to move away from class action cases and move away from disparate impact as a way of challenging structural discrimination, and instead change it to this focus on individual plaintiffs and individual rules or supervisors or things that were the sort of boogeyman who were doing bad things. And so that's how civil rights law developed, and if you look at the patterns, it's a lot of individual claiming, but it didn't have to be that way. Earlier on, there were more class actions, and people saw opportunities to use it in a very transformative way.
Yeah,
so there's a lot of different things, but they can also be, I mean, things can develop that narrow them in terms of what legal remedies are available, but that doesn't mean that that's all rights can do. They can do a lot more if there's institutional support for it.
Right. People forget that McCluskey versus Kemp was 5-4. It's not as if, you know, it's just an inevitable fact of life that discrimination had to be in this formal, narrow sense. You know, that, you know, had Jimmy Carter gotten 3 Supreme Court appointments, you know, instead of Nixon getting 4, you know, things maybe, you know, may have been turned out differently. And the same thing, you know, just this term, again, we saw many, you know, several attempts by the Supreme Court to narrow class action litigation. But again, these are 5-4 decisions. They're not, you know, it's not as if there's no possible way of reading American civil rights law to provide any other remedies. These are, you know, it's a conscious attempt as a political strategy to narrow rights claims, to sort of, you know, to sort of make civil rights unenforceable without taking the political risks of overturning the law outright. And that's not to say that this isn't a limitation of rights. It certainly is, but we just shouldn't accept it as inevitable, which I take to be the lesson of your book.
Yeah, and I think part of the problem also is just the way that people study things. Is they study things by sort of looking at where things ended up by reading the Supreme Court cases, without really thinking about all the things, to use the Robert Cover thing, all the things that the court kills off, all the other possibilities, which is really what the court is doing, and all of that ends up getting masked. This is part of what Michael McCann and I are also working on. Is looking at, if you look at it from the perspective of the activists, sort of community activists that we're looking at in that book, or at these individuals who wrote letters, they saw a lot of possibilities, and they adapted the discourse to this much broader vision of rights in some cases, with more transformative possibilities. And what the institutions are doing is closing those off. But that's a problem with the institutions. It's not a problem with the discourses. It's not inevitable that that happens, even though it sort of seems that way looking backwards and just seeing sort of where things end up.
Yeah, and we should also remember that jurispathy is never complete either. That I think another implication of Cover's no-motion narrative is that the courts will never succeed fully in killing off other interpretations and other lines of normative discourse. And
Right.
in a sense, by accepting this idea of judicial supremacy, we even as an idea or as a strategic possibility, we ignore that. That we should be very forceful in saying, the Supreme Court's interpretation of the 15th Amendment in Shelby County is not correct. It's not. They don't even
Right.
make it good. We can criticize the writers to the Civil Rights Commission, but they seem to have at least as good a formal grasp of the law as the Chief Justice of the United States.
Right.
That it's not, so that there's no reason to accept these decisions as in any way being definitive. They have a certain power. Just
Right.
as if a president vetoes something because he thinks it's unconstitutional, that has power, but it shouldn't be seen as ending a conversation. I think that's a very important lesson to be taken.
Right, and especially when they're 5-4, and a few of the 5 are getting old and maybe dodgy in the heart. Hopefully.
Exactly. So just to finish off very briefly, you're obviously a big Red Sox fan, so you have to be pretty happy. Did you anticipate that they would be in first place in early July? How did you see this year? And boy, does Bobby Valentine ever not look even worse in retrospect than he does at the time. But I had no problem necessarily with letting go of Tito. I think even a good manager, it's very difficult to be a successful manager, for a lot of years in that kind of market. But if the replacement was Bobby Valentine, I'm not sure that was the right thing. But
Right.
it really strikes me that, however the season ends up turning out, that trade with the Dodgers is going to be seen as just one of the turning points in Red Sox history, and really one of the best trades of the last decade. That they sort of are able to repudiate their past mistakes and reload in a way that's made them very competitive.
Yeah, I mean, they made some very smart moves. I mean, as a lifetime Red Sox fan who grew up in New England, I always think they're going to be really good. Actually, I don't think they're going to be really good, but I'm always, in some sense, hopeful that they will be. And so I had some hope this year. I think, there's still weaknesses on the team, and there's a long way to go, and it's not clear when Buchholz is going to pitch again. But it's been a fun team to watch, and that's been gratifying, because last year it wasn't very much fun watching them. And I also think it wasn't just Valentine. It seems
of course not, yeah.
With the whole coaching staff, and people just weren't on the same page and getting along. But yeah, the trade to the Dodgers is really huge. I think they're going to be playing in Los Angeles on the anniversary of the trade, so that'll be an interesting point for reminiscing. But they retooled, and they made smart signings of people and with short-term commitments, and those people have, for the most part, worked out. So it's been a success.
Yeah, and it's really an interesting contrast to the sort of the other team we follow, the Mariners, who seem to still spend a lot of money, and you can just never see it on the field, and they can also just never develop. And that's generally people overrate the tactical side of managing, but it really does seem to me that when your prospects repeatedly fail to develop, that has to at some point, whether it's Wedge or somewhere else in the organization, that there really is something, and as the ancient Raul Ibanez proves, it's not as if nobody can hit home runs in Safeco Field. Like, there's got to be, the fact that Smoke and Ackley just seem to take step back after step back, it really does concern you. Whereas the Red Sox this year have been able to sort of integrate, that some youngsters who have, Bradley came up prematurely, but they've really gotten good performance out of some younger players they needed to get good performances out of. And I really like the way they've kind of slowly integrated Iglesias into the lineup. I think has worked really well.
Yeah, I mean, his batting average on balls in play is something like 800. So I don't know.
Yeah, he's not going to hit four. Obviously he's not going to end up. No, nobody thinks he's going to hit. Continue to hit like Wade Boggs. But certainly, But I think in fairness, the Red Sox also seem to recognize that. They haven't given him. They're not deluded by that into thinking that he's going to be a star hitter, which I think shows some maturity, which is often hard in that kind of a big market. And you do have to think this is finally the year that although the fact that the Yankees are still 4 games over 500 with hitting Vernon Wells cleanup, it makes me scared that they'll still find a way to do it.
They've done really well. I'm pretty amazed. I mean, back to the Mariners, it's really hard to figure because they keep having these players who are these great can't miss prospects that are always getting highly ranked and things, and then they just fizzle. There used to be a problem of them never giving them enough time or enough of a chance, so they call up Eric Davis for 2 weeks and he doesn't hit a bunch of home runs, so they give up on him and give him away. But I think they've gotten smarter about that, but for whatever reason, people they can't get out of slumps, and then when the whole team is slumping, I think pitchers aren't. You look at the Red Sox lineup. Half of those players are coming to bat with a pitcher who's already thrown 20 pitches in the inning, and a lot of their at bats and things. And with the Mariners, they just go down so quickly. So there's something that just never clicks. I don't know. I think it's partly they've been unlucky on things, but it's sort of sad because they're my local team, and I go see them, and I want them to do well. But they're frustrating to watch because they can't score any runs even when they get good pitching.
Yeah, and there's a real and it does seem to me that there has to be an organizational focus. That just as it can't be a coincidence that year after year after year the Royals draw no walks. That there's another team that has lots of young prospects, but they don't want their players to learn the strike zone. Whereas the teams like the Yankees and Red Sox, and there is a bit of a conflict for the baseball fan in that the sort of winningest baseball is not necessarily the most aesthetically pleasing baseball. That I do encourage moves to bring speed back into the game because just having hitters sort of sort out pitches and wait for one to drive is not the most exciting kind of baseball to watch. But nonetheless, if you're serious about winning, you have to do that. And I think now that pitchers are growing up, throwing strikes and that, I think that we've seen a slightly more exciting product despite the attendance being down. That you're not seeing as not every Yankee Red Sox games last 4 hours anymore. That just as happened in the 50s, the kind of Robin Roberts pitchers coming back into vogue. A guy who just is willing to give up some home runs to throw strikes and not fall behind the hitters. So that I think you're going to see a little bit of speed and some more line drive hitting come back into the game too. But you still have to be able to control the strike zone. And both the Mariners and Royals in particular just seem to fail to do that. Whereas that's something both the Red Sox and the Yankees do seem to take seriously. That they want their because as you say that just even if if a Pedroia fights off 11 or 12 pitches and flies out, he's made it easier for the subsequent hitters to hit, and he gets you into the team's bullpen faster. And you'd much rather face their 8th best pitcher than their 2nd best pitcher.
So there's the thing about hitting is contagious, but I do think that that's part of it, and I think it is an organizational philosophy. It goes into their scouting and everything else, and I think that it's also said that that's the thing that can't be taught is plate discipline, that people sort of either have it or don't fairly early on. So I think it goes into what they're trying to do. And there's other models. There's like Napoli, who swings hard all the time and hits a home run. He strikes out a lot and hits a lot of home runs. But he does get deep into counts even when he strikes out. And so that's different from the Dave Kingman or Rob Deere model. So there's value in having a guy who can do that in your lineup at one position.
Right, yeah, you'd never want, and the Red Sox seem to have done a good job of not, that having one Mike Napoli is great, but having, 6 is probably, that they really seem to have, that they really want to seem to have diverse skills in the offense. That if you have all too much of, within reason, if you have too much of any one thing, it makes you vulnerable to certain kinds of pitching, or, that the biggest problem for the Yankees in the postseason is being that if you can get pitchers that nullify their power, they have no other way of scoring, and it doesn't mean that you don't need to be hitting for power, but you need to have a certain and so that you need to have a good leadoff hitter with speed and has a good on base percentage and then some power in the middle of the arm. But you don't want they seem to be thinking of players having diverse roles, and I kind of like that kind of offense. It's not the only way to win, but I like it because it makes you a little less vulnerable to a certain kind of park or a certain kind of pitcher, that you can find different ways to win in different contexts.
Right. Yeah.
So, well,
it'll be that Ortiz can hit lefties all of a sudden.
Yeah, exactly. Well, Ortiz looked done was it 4 or 5 years ago, where it literally looked like he was, looked like a classic old player skills player who was just never gonna, was just done. And what he's doing is just, he could end up, and I thought, nobody could be a better late career DH than Edgar Martinez, but he's really out Edgaring Edgar. I mean, it's just phenomenal, and really without a lot of attention. The kind of year he's having is really just
he's fun. It's fun to watch him hit. He's a fun player to watch.
Right. So, well, anyway, we may have to revisit that later on, but thank you very much for this conversation, and I certainly hope people will. We've whetted people's appetite to pick up This Is Not Civil Rights on numerous Chicago Press, if I'm not mistaken. Is that correct? And looking forward to your next project as well. Yeah, exactly. Yes, we'll make sure to post the appropriately West Coast Powell's link, the appropriately more independent West Coast
ILWU link. Yeah.
Fantastic. So, thank you very much for the conversation, George, and we'll talk to you again soon.
Okay. Thank you. Bye-bye.
Bye.